Good morning, everyone, and thank you very much for joining us for our first webinar of 2026, Changes to Ontario's Construction Act, Risks, Opportunities, and Responsibilities. My name is Shalika Sivathasan, and I am the Administrative Assistant in the Continuing Education Department at the OAA. We will begin today's webinar by acknowledging the land on which we are meeting and calling in from. For millennia, the place we call Ontario has been inhabited by Indigenous peoples and nations who have been stewards of the land and who are deeply connected to its rich cultural and natural landscape. We would like to invite you in a moment of reflection to acknowledge our shared responsibility to address past and present injustices and provide space for Indigenous knowledge and worldviews to shape the architectural landscape of Turtle Island. Before we begin, I would like to share some important information to ensure an effective and professional webinar experience. Please be informed that this session is being recorded for quality and educational purposes. For accessibility, we provide automated closed captioning service available in multiple languages to accommodate the needs of our diverse audience. In order to maintain a stable internet connection, we have muted all participant microphones and disabled video feeds. Kindly note the chat function has also been deactivated. However, we do highly encourage engagement through our Q&A window, which you will find at the bottom of your screen. Feel free to submit any questions you may have for our speakers there. Questions will be addressed during the designated question and answer period at the end of the presentation. For those seeking continuing education learning hours, please note that attendance is crucial. A minimum of 80% attendance is required for these hours to be accredited to your OAA transcript. Please allow a few weeks for the processing and reporting of these hours. And lastly, please note that the presenters do not provide insurance, legal, or practice advice, and the OAA does not bear responsibility for errors or omissions in discussions during the webinar. Now, I'm excited to introduce our speakers for today's session. Lena Wang is certified as a specialist in construction law by the Law Society of Ontario and has experience working on a variety of disputes related to large infrastructure, industrial, and commercial projects. Lena has represented owners, general contractors, and architects in proceedings involving liens, trust claims, delay claims, and professional negligence claims. Lena is an associate of the Canadian Surety Bonding, a designation conferred by the Surety Association of Canada. She is chair of the Advocate Society's Construction Law Practice Group, a co-author of the text Annotated Ontario Construction Act, as well as an adjunct professor at Osgoode Hall Law School. And Katie McGurk joined Glaholt Bowles LLP in 2023 after practicing at a full-service law firm in Hamilton. Katie's practice is now focused exclusively on construction litigation. She has experience representing clients on a variety of infrastructure and commercial projects. She regularly acts for owners, contractors, design professionals, and insurers in claims for breach of contract, negligence, delay, liens, breach of trust, and construction deficiencies. Katie studied law at the University of Ottawa and was called to the Ontario Bar in 2021. Now, please welcome Lena and Katie.
Thank you, Shalika. Good morning, everyone. Katie and I are so pleased to be here this morning with you to be able to talk about changes to our favorite act, the Construction Act. As many of you know, there were a series of amendments that were passed to the Construction Act a few years ago now, and they came into effect. Well, we'll talk about the changes today, which came into effect January 1st of this year, 2026. And the objective of today's webinar is to provide you with practical business-focused guide to these legislative amendments, as well as a roadmap to help you apply and comply with the new rules. For anyone who's interested, we are going to be making these slides available to the OAA, and then they will be sending them to you. So let's get started. Okay, so here's an overview of what we're going to be talking about today. We've grouped the changes into 4 different categories, and we're going to talk about them in different sections. The first section will be holdback and lien. That'll cover probably a big portion of the discussion today. And the big change there is that there is now mandatory annual release of holdback. Second will be adjudication. Third, we're going to cover some administrative updates that will impact the day-to-day operations of potentially your practice and how the Act works. And fourth, but certainly not least, is transition. How are we transitioning into these changes under this Act? And then at the end, we're going to provide your teams with some steps that you can take to comply with these changes. And then we'll do Q&A at the very end. So we have focused on changes that are more likely to be relevant for design professionals in your capacity as a designer and as contract administrator. So the caveat here is we're not covering every single change that's been made to the Act. There are other more minor changes that we're not discussing. We're covering the most significant ones that we think are likely to be applicable to your practice. So just a brief introduction and update, I guess, on how we got where we are. As many of you know, Ontario's Construction Act underwent a pretty major overhaul in 2017, and the changes were rolled out in two different stages, first in 2018 and then in 2019. And those are pretty significant changes to the Construction Act. At that time, the government said that they would re-examine the Act 5 years later, and then they would see how those changes were being received and if any tweaks were necessary. So the Ontario government then appointed our firm's founder, Duncan Glaholt, in 2024 to conduct that 5-year review. And Duncan provided his recommendations in the form of a report as to how to improve the statute as well as the regulations. And those changes are going to be what we're going to discuss with you over the next hour and a half. Okay, so first section is holdback and liens. And for each of our sections, we're going to have this slide where we set out what we're going to talk about. I'm not going to dwell on this slide because we are going to cover each of these. So if you could go to the next slide, Katie. So first up, we moved this up for design professionals because it specifically affects design professionals and only design professionals. Amendments were made regarding lien rights for pre-construction services provided by design professionals. So that would be for designs, plans, drawings, or specifications. Because there have always been a question about whether or not pre-construction design services are lienable. Now, it is presumed under the Act as it sits today, it is presumed that a lien will arise for those pre-construction services for designs, plans, drawings, or specifications where the owner has retained a holdback. So that means, so it's a presumption, right? So it means that the onus is now on the owner to show that that's not the case. The owner then has to show that the services did not enhance the value of the owner's interest in the lands in order to displace the presumption that a lien will arise. So it's not necessarily a significant change as to maybe how the industry was operating, and it's not necessarily changing the case law as it stood, but it's a clarification all the same. Just staying on the topic of liens, when the amendments to the Act were first introduced in 2025, since, as I preview for you, the big change is that there is now mandatory annual release of holdback. Along with that change, initially, it looked like lien rights were also going to expire on an annual basis as well. So this led to a lot of discussion in the industry, mostly I think probably amongst lawyers, that there were going to be more liens. Parties were going to be liening every year on the contract anniversary in order to preserve their lien rights for that year's holdback. Otherwise, their lien rights for that year's holdback were going to expire. So as we sit here today, that is not the law. Lien expiry timelines have not changed as a result of the changes to the 2026 Act. They still remain tied to the publication of in the case of contractors or those who are in contract with an owner, the publication of a certificate of substantial performance, completion, abandonment, or termination of the contract, or for liens of subcontractors or other persons, it's the date that's listed above for the contractor or the last date of lienable services or supply. So there's been no change there. The annual release of holdback has not changed the expiry of lien rights. So this is the most significant change here. And as the name implies, there is now under the Act annual release of holdback, and it is mandatory. Previous to this, the Act after 2018 provided for phase holdback, annual release of holdback for certain contracts if the parties agreed. So that's changed now. Now it's mandatory. And how this works is the trigger for this is the anniversary of the contract. So we'll keep a simple example for a second. I'm not going to talk about how this transitions as we sort of move into these new rules. Katie's going to cover transition provisions as it applies to mandatory release of holdback and otherwise. But basically, after the anniversary of the contract, owners must publish a notice of annual release of holdback within 14 days of that anniversary. Once that, so that notice to the world at large is telling the world at large that the owner intends to pay the holdback and when the owner intends to pay that holdback. And then the owner must release holdback between 60 to 74 days from the date of the notice of annual release, if that holdback is payable. So obviously that invites the question of what does that mean if payable? And basically it boils down to whether or not there are liens that have been preserved or perfected. If not, if there are no liens that are preserved or perfected, then holdback must be released between 60 to 74 days from the publication of that annual release. Now, as I said, previous to 2026, after July 1st, 2018, the Act provided for not mandatory, but sort of optional annual release of holdback or phased release of holdback for certain contracts if the parties agreed. And under that version of the Act, there was a notice of non-payment of holdback that owners could publish, and then the holdback would not flow. As of January 1st, 2026, that is not a form that's available for contracts that has to comply with the annual release of holdback rules. So that's no longer, that form has been repealed. That's no longer a thing. Holdback really is supposed to flow unless there are liens. So holdback is payable. The owner has to retain that holdback until the lien is discharged, if there is a lien, until it's discharged, vacated, or declared expired. After the owner releases the holdback to the contractor is then supposed to release holdback down the chain, down the construction pyramid to subcontractors within 14 days of receipt of the holdback from the owner, unless, again, there's a lien that's preserved or perfected in respect of the subcontract. And then so on and so forth down the chain, subcontractors pay out holdback that's been released to them to the subcontractors, etc. So we're going to look at a flow chart because sometimes I find it's easier just to visualize how these obligations will work. So here we're looking at a chart that doesn't have any actual calendar days. So this just sets out the obligations under the Act. So after the contract is formed, the first year after that, you have your annual contract anniversary. And then 14 days from that, the owner must publish the notice of annual release of holdback. You could publish it earlier than 14 days, obviously, but you must do so no later than the 14th day after the annual contract anniversary. Then on day 60, anywhere between day 60 and before day 74, the owner would check title or check its records to see if there have been preserved liens. And if there are no liens, then holdback is supposed to flow. Holdback is supposed to be paid out and should be paid out to the contractor. If there is a lien, and that lien has not been discharged, vacated, or declared expired, so the lien hasn't been dealt with, in other words, then the owner has to continue to retain that holdback until the circumstances preventing payment cease to exist. So if there's a lien that's preventing payment, then it has to be when the lien is dealt with. Then those circumstances cease to exist. And then within no later than 14 days after that, the owner shall release holdback to the contractor. So that's the obligations here in the form of a flow chart. Now we're going to look at a few scenarios. We're adding some more dates to these flow charts just to show you what some of the different scenarios, where they will land you in terms of actual release of holdback dates. So these are hypothetical scenarios that we've invented, and we picked dates to make the scenario simple. So we haven't, again, accounted for the transition into these rules. Okay, so in this scenario, we have January 6, 2026 as the contract formation date. So you've entered into a contract on January 6, 2027. That's your annual contract anniversary. No later than 14 days after that, the owner shall publish a notice of annual release of holdback. That becomes day 1. In this case, the owner has published it less than 14 days. The owner is being very prompt, probably getting great advice from those in the audience as contract administrators. And the owner publishes it on January 18, 2027. That becomes day 1 in our calculation. Then anytime between day 60 and day 74, let's say day 60, which is March 19th, the owner looks at whether or not liens have been preserved or perfected in respect of the contract. If there are no liens, then the owner can and must release the holdback anytime between day 60 to day 74. So that's why I say can and must. You must release no later than day 74, but there's that 14-day window during which you can release your holdback. So long as when you release your holdback, right before you release it, there are no liens on title or no liens that have been preserved or perfected. So that takes you in this scenario to March 19th, day 60, and April 2nd, day 74. And if we go to the next scenario, so we're making things a little bit more complicated here, there will be a lien in this case, but we're keeping the same contract formation, contract anniversary dates, and then we're also keeping the same day 1, the publication of the notice of annual release of holdback. In this case, if a lien is preserved before day 60, so that is before the owner can release holdback. So in this case, we picked the lien is preserved actually on day 2, right? The notice goes out and someone preserves the lien. January 19, 2027, day 2, a lien is preserved. And then in this case, we've chosen that the lien was vacated January 28, 2027. So a contractor has paid a security into court or cash security or bond to vacate that lien on day 10. Then the owner must release holdback to the contractor between day 60 and day 74, which is the same result as we have in scenario 1. So this scenario is assuming that there's only that one lien that we've provided for here on January 19 and it's been vacated. And by the time the owner is releasing holdback, there's no other liens. But the point here is to show that if the lien is preserved and vacated during that 60 to 74 before the 60th day, then the date of release of holdback does not change. It's the same as if there was no lien in scenario 1. And then the release of holdback to subcontractors will follow, as I've talked about. So this is what we're calling scenario 3. And here, again, we have the same contract formation date, same annual contract anniversary date, same publication of notice of annual release of holdback date. Again, we're going to imagine that there is a lien that went on title, and it went on title or was preserved January 19, 2027, day 2. However, in this case, for whatever reason, the lien is not vacated until day 82. We've chosen just the date that's outside of that's later than day 74. And so, of course, when the lien is still not vacated by day 74, the owner cannot release holdback. The owner has to continue to retain that holdback. And then once the lien is vacated, the owner has and must release the holdback within 14 days. So that takes the owner to day 96, April 24, 2027. So this did delay the release of holdback. So this is different than scenario 2 because the lien was not dealt with before day 74. Now, another scenario that we haven't shown on this slide is the possibility that a lien can be preserved on day 62, right? Because remember, on day 60, the owner can release holdback, but the owner has until day 74 to release holdback if there are no liens. But if on day 62, maybe the owner intends to release but hasn't actually released it yet, a lien goes on title or a lien is preserved. Now the owner can't release holdback and has to hold on to the holdback until that lien is vacated or otherwise dealt with. And then again, once the lien is vacated, the owner has 14 days to release. So that's why we've been our advice to owners or to those who are assisting owners with these obligations is that because liens can continue to be preserved after day 60 and after day 74, to the extent possible, you should do your searches on day 60 and release that holdback on day 60 or day 61, whatever is practical, so that you don't run into, you're ready to release, a lien goes on, lien's dealt with, you're ready to release, a lien goes on. So that way we say, do your searches, day 60, release the holdback. The only other comment I'll make, sorry, just if you could go back for 1 second, Katie, on this slide, is that moving on down the pyramid, once the owner has released holdback to the contractor, a subcontractor could still lien, in theory. And that lien would prevent the contractor from releasing holdback that's now in the contractor's hand to the subcontractor. So that section of the Act says the contractor must release the accrued holdback in respect of the services or materials supplied by the subcontractor unless a lien has been preserved or perfected in respect of the subcontract. So that's all to say, we think that means if, for example, the mechanical subcontractor liens, the contractor has to withhold holdback from the mechanical subcontractor, but can release holdback to the other subcontractor streams. Okay, and then if you go to, so this is really to summarize the significant changes that's now in effect to the Act. Annual release of holdback. Previously, owners, contractors, subcontractors could withhold all or part of the holdback if they issued the notice of non-payment that I talked about by a certain deadline. Now that's not available. There is no notice of non-payment of holdback. As a result, holdback must be paid annually without any deduction, set off, or withholding. And payers are prohibited from using holdback to pay for replacement work or such when a contractor or subcontractor has been terminated or abandoned. So this is quite a significant change. And, as with all changes in law, until we see it being implemented, we don't really know exactly how the industry will adapt and how it'll play out. So it'll definitely be interesting to see how the industry adjusts to this.
So the next major section we're talking about today is adjudication. Some of you might be familiar with the process, and Ontario introduced a mandatory adjudication process under the Construction Act in 2019. The purpose of the scheme was to create an out-of-court process to address in-project disputes, keep monies moving, and avoid projects getting bogged down by court litigation and multiple liens. The amendments to those provisions are meant to improve the fairness and efficiency of the process. Now that we've had adjudication for a little more than 6 years, the process has matured. We've had some opportunity to see how it's been working in Ontario. And these changes of the product are the recommendations in the Glaholt report about adjudication. So just brief overview of what we're going to look at. We're going to look at new deadlines to commence adjudications, a slightly expanded scope of adjudications, the introduction of private adjudicators to the scheme, the publication of adjudication determinations, which is what we call decisions in adjudication proceedings. And finally, we're going to look at a sample adjudication timeline, less because there are significant changes to that, but more just to impress kind of the speed of the process and for a good overview of how the whole thing works. So deadlines, the act has been amended to create I think, a more clear deadline for parties to commence an adjudication. There's now a defined limitation period for when you can start one. Prior to these changes, the act just prohibited you from commencing an adjudication after the contract or subcontract was completed. Now, completion is a defined term under the act. However, this still did create some confusion and ambiguity. What does completion? Where is completion? And you also had the case where there were some matters being adjudicated, many years after people were on site. But the project still hadn't met that completion milestone, kind of interfering with the purpose of this process, which is to resolve mainly in-project disputes and disputes for holdback. So we've clarified this now with some clear deadlines. And if these triggering events look familiar to you, it's because they're modeled after the lien preservation timelines. These are the triggering events that start your deadline to preserve your lien. Which is 60 days, but for adjudication, it's 90 days. So adjudications in respect of a contract, so a direct agreement with the owner, must be commenced within 90 days of completion, abandonment, or termination of the contract. For subcontractors, adjudications must be commenced within 90 days of the earliest of those 3 dates: completion, abandonment, termination, or certified completion of a subcontract, or the last date of supply. Again, so the practice point here too, thinking about, similar to your lien deadlines, thinking about those 60 days from those triggering events, being aware of those triggering events and when they happen, because now you have 90 days to adjudicate once you meet those milestones. So this scope of adjudication has been, I would say, slightly expanded. These are the list of, types of disputes that can be adjudicated. The ones that are in bold, the number 6 and the sub criteria, are what is new. But just to look at all the matters, you could always adjudicate the value of services and materials, payment under contract, including in respect of a change order, a dispute that's subject of a notice of non-payment under the prompt payment regimes, amounts retained for set-off, and payment of the holdback. And then what is new is any of the following matters if they're reasonably necessary to resolve a dispute in order to make a determination. And those sub-criteria, those sub-issues are scope of work, request for a change, and request for extension of time. Why were these changes made? They kind of go hand in hand with another change. So the act previously provided that you could only adjudicate a single matter. And that created some confusion because, well, what is a single matter? Any dispute often has multiple issues. If I say that I'm to be paid, you might assert a set off against me. Those are two separate issues, but it's the same dispute. So the act was changed to amend it to allow parties to prohibit parties from adjudicating more than one dispute rather than one matter. So this kind of goes hand in hand in that saying, yes, you can only adjudicate one dispute, but that one dispute may require the adjudicator to decide, these sub-issues. For example, we're looking at 6 sub 2, request for a change in the contract price. To decide whether or not someone's entitled to payment of a change, you also, and evaluating the amount to be paid, you also need to decide entitlement to that change itself. So and maybe deciding whether what is actually within and outside of scope. So all to say, this is a minor change, but clarifies that adjudications shouldn't be, or sorry, claimants shouldn't be unsuccessful because their one issue is a little bit complex and may require the adjudicator to decide sub issues while still preserving adjudication is supposed to be, an issue by issue process for parties to resolve, a single problem during a construction dispute. Oops. So there are some matters now specified that can't be adjudicated, such as whether a project agreement has been substantially completed, also to when certain milestones have been reached to entitle a party to payment. So that's a new modification. And then number 2 in bold, this is new and could provide some opportunity or potentially more headaches for design professionals. You tell us, but parties to a project agreement where there is an independent certifier, and that certifier is also a certified adjudicator, parties can request that that certifier be the adjudicator for the dispute. This could create some opportunity for those interested to expand the role of the independent certifier that's now specifically provided for by the Act. Probably the most controversial change just in how it's been rolled out is that parties are now allowed to agree to appoint private adjudicators. Until these amendments, adjudications could only be conducted by an adjudicator listed in the registry that's maintained by ODAC. ODAC is the authority who administers adjudications in Ontario and also certifies adjudicators. Now, the act has been amended to allow for both, roster registry adjudicators and private adjudicators, where one, there is a written signed agreement that discloses the applicable terms and the adjudicator's fee that the parties have agreed to, and 2, if the adjudicator fee amounts to an hourly rate of at least $1,000. So that's the controversial piece, having the minimum hourly rate for private adjudicators be $1,000. What is the rationale for this? The purpose is to, I think, make adjudication more attractive to specialized decision makers and parties who have, and adjudicators who have experience on, large commercial or large infrastructure projects, and to make it a little bit more attractive where the current fee structure for ODAC perhaps is not the most attractive. So private adjudicators do still have to be qualified by ODAC, and they cannot sit on the ODAC roster and practice as private adjudicators at the same time, but they are able to kind of trade certificates and come on and off the roster. They just can't be on both at the same time, which makes sense, that you can't both offer private services but be on the roster to be able to kind of go around ODAC and their fee structure. So publication of determinations, that's what we call decisions in adjudication proceedings. Prior to these amendments, determinations were private and confidential. The Ontario courts were critical of this in some cases. One decision in particular, now the judges are in the position of reviewing these adjudication determinations on applications for judicial review, which is what the step parties can take to try and have the decision set aside. One decision particularly struck a nerve with the industry where I think the judge, was critical of the fact that this is a public, statutorily created process. Why should the decisions be secret? So that feedback was taken on, and now adjudication determinations will be published on ODAC's website, not to have any precedential value, but for the purpose of allowing transparency and giving that to the public, and of course, maintaining the credibility of the process itself. However, there are some opportunities for anonymization. Before publication, ODAC is required to ask each party whether, in their view, it should be anonymized. And if the party answers in the affirmative, ODAC will request each party indicate which portions they believe identify the parties, and to ensure each portion identified does not appear in the published version. So this is a change. This is a change that is enforced but doesn't take immediately effect. Sorry, does not take immediate effect. This will apply to all adjudications where the notice of adjudication was given on or after January 1st, 2027. So here's an overview of the adjudication process with the timelines. I'm just going to walk through this fairly briefly. You can see that you've got at the very top your 90 days from your triggering event that we talked about. The process starts with the claimant giving a notice of adjudication. They recommend an adjudicator who either the parties can agree to. If they agree, the adjudicator will decide whether or not they want the appointment. Within hearing from the adjudicator, the proposed adjudicator, ODAC will select someone, whether it be that adjudicator who accepted, or they will appoint somebody else. And then within that adjudicator, and that can happen within 7 days in my experience, it's even quicker. ODAC is pretty quick to appoint somebody once they get that decision from the parties and the adjudicator, or in the proposed adjudicator, I should say. Once the adjudicator is appointed, the claimant has 5 days to transmit their documents. That might be their submissions, the contract, the key documents they want to rely on. The respondent has 7 days to respond, and the process is designed such that a decision will be given within 30 or 44 days if the parties agree to extend to that 44-day period. And parties can agree between themselves and the adjudicator to vary the process, but you can see just on this outline how quick it is designed to run. I think this is particularly important for claimants or parties who are, for architects who are considering becoming claimants and adjudicating certain matters, as well as those who are assisting respondents in responding to an adjudication. It's kind of an incentive to be organized, given how quickly you not just have to get the submissions in, but all the documents have to be collated and submitted.
Okay, Section 3 on administration. Okay, so we're going to cover some of the more pertinent and notable changes in this area we've called, the administrative changes. There are others, but we're going to cover proper invoices and the new deeming rule. If you could go to the next slide, we'll do that first. So just to provide some context, prompt payment, as Katie has discussed, is triggered by the owner's receipt of a proper invoice. And proper invoices are the invoices submitted by a contractor to an owner. Now, of course, if you're going to call something proper invoice under in a piece of legislation, you have to tell the world what makes it a proper invoice. And the Act has always provided for a specific list of requirements for what constitutes a proper invoice. there have been some changes to that list. Some are very minor, and I'll walk through what I think is probably the most notable change. The changes were, the way the changes were made, it wasn't easy for us to just like highlight the actual change. So what we've shown on the slide is the act as it currently sits today. So as it sits today, this is what's required for an invoice to be a proper invoice from a contractor to an owner. In number 2, the date of the invoice and the period, milestone, or other contractual payment entitlement to which the invoice relates. There's a change there because that used to only provide for invoices that's a temporal period. So it would be monthly or if quarterly or whatever is agreed to. But now the change is made so that it recognizes that payments could be a contractual milestone basis, right? So the period, milestone, or other contractual payment entitlement. So that's a change, and that just reflects how certain contracts are administered and operated in the industry. And then there were other changes that are just semantic, or you could call them cleanup. For example, I think in number 3, where it says other authorization under which the services materials were supplied, that used to say their contract authority. So authority has now changed to authorization. Minor changes like that we have not highlighted. Just a note on number 7, any other information that may be prescribed. So in the Construction Act, prescribed means anything that's prescribed by regulations. So the government could add requirements to this list without modifying this section of the Construction Act by modifying the regulation. So that means, every so often you need to go and actually check the regulation to this act to make sure that there have not been new requirements added to this list to make sure you comply with it. And then number 8 is, of course, you can actually agree with your contracting party to add other things to this list, to this list of what is a proper invoice. You can't contract out of the Construction Act, so you can't agree to delete, right, like 1 to 5 from this list. But you can agree with your contracting party to add to this list. So the major change, though, to proper invoice and why we're talking about it is that we now have something called a deeming provision. So before this year, prompt payment was triggered by a strictly compliant proper invoice. And so what happens, right, when a contractor submits an invoice that's not proper, or the owner says is not proper, then does that mean the prompt payment provision is never triggered and the owner doesn't have to either send a notice of non-payment or pay? So that was sort of a loophole, or at least a way for owners to try to delay payment cycles by disputing the technical information was missing from those invoices. And so now this new deeming provision is supposed to address that concern. Now, invoices that do not meet the criteria of a proper invoice are deemed to be proper unless the owner notifies the contractor of the deficiency in the invoice. And that notice has to be in writing, and it has to be within 7 days of the owner's receipt of that invoice. So what that really does is, one, it puts the onus on the owner, right? You can't just sit back and sort of like see a deficiency and wait until the last day and then say, or just never say anything at all and say, I'm not going to pay you because there's a deficiency, and therefore my obligations under the prompt payment regime are not triggered, because that's really not the purpose of those changes to the act. The purpose is to get money flowing for payment to be prompt. And so now if you see something that's deficient, you have to tell the contractor, owner has to tell the contractor, otherwise that invoice is deemed by the act to be proper. And that means then you have to pay, or you have to send a notice of non-payment as if that invoice was proper all along. So then once an invoice has been deemed to be proper, the prompt payment timelines apply. So as I said, payment is supposed to flow within 28 days unless a notice of non-payment is issued within 14 days. If an invoice is not proper and the owner does notify the contractor of the deficiency in the invoice, my reading of the Act as it stands today, because we're still all learning, how is this, what does this mean, how are we going to operate it, is that the timeline for payment or for notice of non-payment is then like kicked out. So it runs from the date of the corrected invoice if the contractor does correct the invoice after the owner has told them this is not a proper invoice. Because once it's corrected, it becomes a proper invoice. So this is a change, right? And what it means practically is that it's shifted a lot of the administrative burden onto owners, because owners now not only have to review within 14 days really to decide if they're going to pay or not pay, right? So they can issue the notice of non-payment. They have to review and decide within 7 days if there's anything wrong with the proper invoice, right? If there's a technical deficiency in the proper invoice, and then they have to tell the contractor. And when I say that the burden has shifted to the owner, I understand that, in the audience, those that are performing contract administrative duties, that burden has probably most likely shifted onto you. So you need to do your review and identify these technical deficiencies. So then the owner can instruct you or agree for you to issue a notice to tell the contractor that the invoice is not proper. So it's really important for the review to happen promptly. And so given that administrative burden has shifted onto the owner and contract administrators, we thought it would make sense for us to review what we prepared as a sample notice of deficient invoice that you can feel free to adopt. Obviously not the, nothing that has our firm's logo, just the content of the sample. So to start, and some of this is going to be, common sense, but to start the notice, you're going to want to date your notice, right? The date of this is very important. The date that you sent this notice. And you're going to want it to make clear how you're delivering it. Email, fax, to the extent that's, still around. Who did you send it to? This notice should clearly set out the parties that's involved and the role of the respective parties, right? It should reference the contract reference number, and the reline should be very clear, right? This is a notice of deficient invoice. That should be clearly stated, and the invoice number should be clear, right? The reference should be in the reline, should be in the body. And then it should actually state, as we've done here, that the invoice that's being referenced is rejected, right? There's no ambiguity about this. It's rejected because it fails to meet the requirements of a proper invoice. And here, we've said, like, as stipulated in the Contract and/or Construction Act, and we've cited the Construction Act. And then the owner is required and should say what the defects are and how it can be addressed by the contractor. What can you do to correct it? And then finally, it's important, I think, to say, until you address these defects and you resubmitted the invoice, this invoice, and you should say the reference number again, it continues to fail to be a proper invoice, right? So that means, and the owner is not going to honor its obligations to pay it, because your obligation to pay is triggered by, owner's obligation to pay is triggered by the receipt of a proper invoice. Until you fix that and it's a proper invoice, I've given you notice, I'm not going to pay. So that, if you're going to take that position, that should be clearly stated in this notice.
Okay, so moving on to our final category of changes. This is more on transition issues, timing, and carve-outs. As I said earlier, most of these changes are already in effect, but some of the provisions have individual transition periods built in to give the industry a little more time to get ready and align their respective practices for compliance. So the general application of amendments, as I said, they already generally apply as of January 1st of this year. Look at the special treatment for annual holdback and some of the carve-outs, including P3 projects and what we call old Act projects where the contract was projects that predate July 1st, 2018. So generally everything is in force. However, for annual release of holdback, the first annual release will happen on the second anniversary of the contract after January 1st, 2026. So what does that mean? If, for example, I enter into a contract on December 10th, 2025, the first annual release won't be until December 10th, 2027, because that's the second anniversary that follows January 1st, 2026, the day in force. Similarly, if the contract was formed August of 2024, the first annual release date will be August 2027. So for absolute clarity, no projects unless are releasing mandatory annual holdback in 2026 because of this transition period. Also important to note, on that first release date, you're not just releasing the annual holdback for that release. On the first annual release date, payers are releasing all of the holdback accrued to date, not just the holdback for the year 2026, but the holdback on the project to date. So this is an important carve out for P3 projects. It's also caused a little bit of confusion in the industry. All three P3 projects are not exempt, but there are a list of P3 projects that where the contract was formed before January 1st, 2026. There's a list in the regulation of contracts that will not be subject to the annual holdback release. What follows is a very messy and busy slide, just showing you that those projects that are currently under the regulation prescribed as not being a part of this scheme. You can see they all predate January 2026. And the reason this is in a regulation and not in the act, as Lena mentioned before, is so that the government can more easily update. So projects could be added to this list. This is not static, but this is how the regulation currently sits as of this morning. These projects are exempt from annual release. If your project is not on this list, it's likely not exempt from annual release. Unless, of course, it is a project that commenced a long time ago, before July 1st, 2018, which was the transition period for the last round of amendments that we mentioned 5 years ago. So projects that are still under the old Construction Lien Act regime before the last round of amendments, where we even changed the name of the act, these new changes will not apply to those. That means that adjudication is still not available. It means that annual holdback release will not apply. It means prompt payment won't be enforced for that either, as well as the old lien timelines will apply for those old projects. Okay, so we're going to talk a little bit about some of the practical effects of these changes and how they could be incorporated in best practices, based for you, but based on your role in the project.
Okay, so for payers, I think should be, as you can tell from what we've talked about, workflows for reviewing proper invoices or invoices to see if they are proper need to be revised, because you're now doing it on a quicker timeline, and there's clear consequences if you don't advise the contractor that it's not a proper invoice within the 7 days. So that needs to be done promptly. And then deficiency notices for those invoices need to be issued quickly. And then, of course, there's now this additional that owners need to take of issuing notices of annual release of holdback. And that, you have 14 days from the contract anniversary to do that. And when you issue that notice of annual release of holdback, you will need to say how much money that is that holdback that's the subject of that release. Now, we don't have, last time I checked, which was last week, Form 6, which is the notice of annual release holdback form, was not publicly available online yet. So I don't know, I can't tell you specifically how that breakdown looks. But I think the note here is that owners will need to be ready to have their accounting, information updated and ready, so that they can tell the world at large what that value of that holdback is that's been accrued in the last year.
And for designers and contract administrators in that role, a few actions to diarize and implement. Since the amendment, now create a presumption that liens will arise for design, plans, drawings, or specifications or plan improvements where the owner has retained a holdback. Designers now, it was always a point to consider to negotiate whether or not there should be a holdback, but this may create some incentive for you to want to provide for that in your contract, that there is a holdback, to clarify that you have lien rights and lower, the risk of registering pre-construction liens for pre-construction services, given this kind of clarification in the whole scheme. It's important to understand where you sit in the contractual chain, because a lot of these deadlines flow from that. A lot of designers are subcontractors. If they're not directly contracting with the owner, they are also contractors as defined by the Act, as strange as that may seem. So that's important, because the payment deadlines and invoice dates have to be aligned with based on where you sit. So consider that and diarize accordingly. Similarly, if you have sub-consultants working for you, diarize those deadlines to complete your own obligations to deliver notices of non-payment and notices of deficiency. We've now seen a realigning, your administrative processes from the, originally we just had 14 days to do a notice of non-payment. Now there's this notice of deficiency that's required within 7 days. Otherwise, you risk that it's deemed a proper invoice. So making sure that you diarize that, not just with respect to the party above you, but to your sub-consultants. Particularly if you get a notice above, being ready and prepared to flow it downstream as necessary. And then, of course, diarizing, deadlines for yourself if you are a payment administrator, payment certifier, to making sure that you are reviewing the contractor's invoices on those deadlines, being mindful of the owner's deadlines that you're working for. For those who are managing compliance, a couple things to think about, reviewing and updating your contracts or getting advice on that, to account for new proper invoice deeming, annual notices, adjudication options. If you are technically a subcontractor, considering whether you want to add a provision that requires the party above you to notify you of the date of its proper invoices was submitted to the owner, as well as the date of the prime contract, so you can be ready for some of those annual release dates that will come into force. Consider whether you're interested in private adjudicators and how you might want to provide for that in your contract. Most importantly, providing training or guidance to your staff and the folks who are involved in making this all work day to day, so that you can be ready for these amendments, particularly annual release, adjudication, and lien rights. Okay, so we're exactly at the hour, which is what we'd hoped to do. We're going to take some questions.
Yeah, we have a lot of questions
Yes.
in the Q&A, which is great.
Yes, so just a quick reminder to those on the call to please input your questions in the Q&A box if you haven't already. Um, and a quick reminder that our speakers today cannot provide legal advice, so this is a general information session. So just keep that in mind with your questions. And also, I believe there are a few questions in the Q&A box that are directed to the OAA. So if in that case, we will get in touch with those attendees following the presentation. So Lena and Katie, feel free to go ahead.
Okay.
Thank you.
So maybe Katie and I would just take turns reading out the questions, and then so when we answer them, it makes sense. Because I don't know if everyone can see the questions. No, okay.
No.
Okay, so the first question is, you've mentioned that a 60-day lien period commences after notice of annual release of holdback, but also mentioned earlier that lien right expiry hasn't changed and still apply until substantial performance. I'm just gonna, and then you said this appears to be contradictory. I'm gonna pause there before the next part, which has a separate question. So lien timelines have not changed. The 60-day period following notice of annual release of holdback is for release of holdback that's been accrued. It has nothing to do with lien rights. My point there, I think what you're referring to is to say that even though you have the 60 to 74-day period for releasing holdback after you've given notice, it doesn't mean that parties cannot continue to lien, right? It's sort of a holdover from when at some point lien rights were going to be expiring on an annual basis. And in that case, it would make sense for there to be notice. And then after a period after the notice, you release the holdback because that would be the period during which parties could preserve their liens. But since the changes have changed, and there's no longer liens are not expiring annually. There's a bit of a strange, like if you work out the scenarios, that's why there's a bit of a strange scenario where there's 60 to 74 days in a period for you to be releasing holdback, but parties could still lien even after. That was the point there. And then the next part is, would mandatory annual release change how future liens get paid out for trades that holdback has already been released for if they haven't preserved a lien after holdback release but still have lien rights? I think the answer to that is you wouldn't get, if you've received holdback, you're not going to get paid that twice. So when you lien at the end of the project, during whatever process that follows the lien, you will submit your statement of account and it will show what you have been paid and what you haven't been paid. And then your lien would be for the unpaid amount. It wouldn't, like, you're not going to get paid twice. I think that's the question. Sorry, that's the answer.
Yeah. So I'll look at the next question, and I can see the timestamp. So some of these may have been answered later on, but I'll still answer them just to reinforce some of these points. The next question is, are these changes applicable to existing contracts entered into before 2025? The answer is yes. Aside from those contracts that are on that P3 list that I went through, or the contracts that for the improvements that are before that old date, the July 1st, 2018 date. But yes, these are applicable to existing contracts. But there is that the holdback is released for something that was entered into before 2025. The holdback will be released in 2027 on the annual, following that anniversary of the contract formation.
Okay, so the next question, whoever asked this question, you were like in my head as I was preparing for this, basically, yesterday. So the question is, does the provision for deemed proper invoices affect when the clock starts on the 28-day period to pay? When does the clock start in each of the following scenarios? Scenario 1, a proper invoice is submitted on day 1. Scenario 2, an invoice is submitted on day 1, but no notice is issued by the owner declaring the invoice improper. Scenario 3, an invoice is submitted on day 1 and a notice is issued by the owner within the 7-day period declaring the invoice improper. A revised proper invoice is submitted on day 3. So I'll caveat my answer by saying there are obviously no case law, like there's no decisions saying one way or the other. These changes are very new and there's actually very few lawyers or firms or organizations who've written about this change in the level of detail that you're asking about, that I was thinking about yesterday. But I will give you what I think is an interpretation I can stand behind. So if a proper invoice is submitted on day 1, then it's the same timelines that the Act provides for, has always provided for. So 14 days after that, if you're not going to pay, you have to issue a notice of non-payment. Otherwise, within date 28, you have to pay as the owner. An invoice is submitted on day 1, but it's not proper, and the owner doesn't tell the contractor it's not proper. Then it becomes a deemed invoice, right? If within 7 days the owner doesn't tell the contractor it's not a proper invoice, it becomes a deemed proper invoice. I think then on day 14, you have to issue a notice of non-payment if you're not going to pay, or you have to pay on no later than day 28. Your notice of non-payment on day 14 or earlier cannot say, I'm not going to pay you because the invoice is not proper, because it's already been deemed to be a proper invoice. Now, that's the purpose of the deeming provision. In your scenario 3, which I think I talked about when I talked about that slide, it would be kicked out to when a revised proper invoice is submitted on day 8, then day 8 sort of becomes like day 1 again. 14 days after that, it's a notice of non-payment. If you're not going to pay, for 28 days, no later than 28 days, you have to pay the owner.
Next question, is a client required by the Construction Act to retain holdback on architectural services provided by, provided by the architect? So I'll give you a lawyer's answer. It depends. So what the Act says about, and this is a common question that we get because it's often architects, and particularly for some of the pre-construction work that we talked about, that it's unclear. The Act requires that each payer under a contract or subcontract under which a lien may arise shall retain a holdback of equal to 10% of the services actually supplied, until all liens that can be claimed against the holdback have been expired, satisfied, discharged, or otherwise provided for. So that was fast. So it's their owner. So you said client. I'm going to interpret that as owner. The owner is required to retain holdback for architectural services where those are lienable services. And that's why, even before this change, about, the deemed lien for pre-construction services, whether or not you negotiate a holdback doesn't matter because it's part of the evidence about whether services were ultimately lienable, meaning that a lien arose for those services. So the answer is it depends. It is something that you may want to consider when you're negotiating, but not always, and sometimes yes. So it's kind of a fact-specific question, and I realize that it might not be satisfying, but that's what I have.
So I'm checking these off as we answer them, and that's why.
Okay.
Thank you. Yeah. That's why it shifted up for you. Okay, so the next one is the architect obviously has to spend some time within this process. I think this is the process I think this is adjudication. No matter how efficient or amicably matters are dealt with, is the architect's time completely without payment regardless of their responsibility for the circumstances? So I think I read this right after you talked about adjudication. So I'm going to answer it as if it's about adjudication. So obviously it's something you should think about ahead of time, something you should negotiate with the owner. If you're required to assist with adjudication, like you're not a party to the adjudication and you're required to assist because you have the records or you have the knowledge, whatever the reason is, you should negotiate that with the owner. I will note that the OAA standard form contract does list these types of services as an additional service that you would check off in your schedule. So you can take that when you're negotiating with owners.
Next question. Is it the owner's responsibility to provide notice of improper invoice to the contractor, or is this up to the architect to do so? So I would say under the construction act, it is the owner's responsibility. That's how it's written. But if managing, especially if you're a payment certifier, if managing notices of non-payment and a notice of or deficient invoice, if managing that process is part of your scope under your contract, I mean, contractually, vis-a-vis the owner, that is part of your duties. But under the Construction Act, it is the owner's, obligation to deliver these notices and the owner's obligation to pay. But practically, yes, it could be your responsibility. But that's vis-a-vis your client, who I assume is the owner, in your question.
Okay, the next question is, it was mentioned during review of holdback release section that notice of non-payment form was no longer valid. Was this just relating to notice of non-payment of holdback? Notice of non-payment of other monthly or milestone invoices still apply. Correct. Notice of non-payment of holdback, that form has been repealed. Notice of non-payment of what I'll call progress application, proper invoices, monthly payment, contractual payments, still very much in effect. And that is what we've been talking about when we say you have to review the invoice to determine if it's proper. If not, then that kicks off your timeline for issuing a notice of non-payment or having to pay. So prompt payment hasn't really been touched except for example, the changes to what is a proper invoice and the deemed payment and the deemed proper invoice section. The timelines for prompt payment has not changed.
The next question, does prompt payment by owner also apply to the consultant's invoices? Yes, it does. So, the Construction Act refers only to, as categories of payees, subcontractors, and contractors. So, if your client is the owner, you are a contractor for the purpose of the act, and the prompt payment regime does apply. So you are to be paid in 28 days, provided you don't get any of these notices. That's what the act requires. There's a couple here to the OAA, which Shalika mentioned we won't be answering.
Yeah. So then the next one, skipping that one for the OAA. The next one is the anniversary date the effective date of the contract? Very good question. The Act says
a question we've received from other lawyers also.
We have. Yeah.
Sorry.
The Act says the anniversary is the date the contract is entered into. Now, so the question is what is the date that the contract is entered into? I think if the contract doesn't specifically address it, so if the contract doesn't have an effective date or it doesn't say it's the date the contract, what is the date the contract is entered into, it may be the date that parties have signed or agreed. That would depend on, I think, the type of contract, the circumstances. Ideally, and this is practical advice, your contract should specify, right? Now it should specify, if it always said there was an effective date, now it should probably say the effective date is this, and for the purpose of the Construction Act, the contract anniversary date is the effective date. So then there's no ambiguity. That's a change I would recommend making to anybody who's entering into contracts, so the parties are in agreement about what that date is. Okay. Do you want to do the next one?
The next one is very fact specific. So timelines for contract are extended due to circumstances outside of the contractor's control, a flood on the site. This leads to additional fees due to the consultants due to contract extension. Can the owner hold back money from the contractor due to additional consulting fees, stating the contractor should have resolved the matter more quickly, thus reducing their obligations to the architect/engineer? So I suspect this is a real life circumstance. So I'll give you my first impression. It sounds like potentially it could be a force majeure, or we don't know, what's the root cause of the flood and who's at fault, if anybody. And that will depend on the contract and how it deals with those kinds of circumstances. The contract, meaning the construction contract between the owner and the contractor. And it's hard to give you a really good analysis without looking at that, but that's the first place that you would go. And I have seen contracts that provide for this, and I have seen people without these provisions try to make these arguments to different degrees of success. So I don't have a better answer other than that's going to go to the contract, but nothing in the act that I can really think of would necessarily address that.
That's right. Yeah. Okay. So this is the last one we have for now. So if you have any other questions, you can enter them into the chat or in the Q&A because we do have a bit more time. The last one we have right now is, how would you recommend we respond to owners who ask us to prepare and publish Form 6, Notice of Annual Release Holdback on their behalf? I think if your contract with the owner says in the beginning, right, as part of your services you're going to provide, says you're going to do it, then when they ask you to do it, it's part of your contract obligation to do it. But maybe what you're asking is, if initially the owner asks you to do it, how would I advise you respond? I think that's very much a business decision. You can decide you don't want to take on that service. Like you don't want to take on that task. You can tell the owner, there's certain things I'm not comfortable doing or qualified doing, or however you want to say it. And they may be filling out this form. That is a Construction Act form, right? And you can tell the owner that, your scope and your price reflects that. That's totally up to you, right? Same as how you may decide that you're not going to administer, a certain portion of the contract, or you're not going to determine disputes between the owner and contractor on delay issues, right? I've seen design professionals say, that's just not something I'm going to take on, even if the CCDC form says they are the party that decides those disputes at first instance. You can negotiate with the owner and say, those are not services that I can provide. In some cases, like in the delay case, makes sense. You're not a delay, you're not a scheduling expert, most likely. Why would you be the one to be deciding if there's been a delay, if there's been if the owner should grant a request for an extension of time on the contract, depending on, what kind of project it is and what kind of schedule you're looking at. So I think this would be the same as that. You can negotiate additional services such as that, and whether or not you would be providing that to the owner. And, we also don't know what Form 6 says, right? Like if it's a very...
I haven't seen it yet, actually. Yeah.
If it's a very legal form, maybe it's very, you could have a very good argument for saying, I'm not going to do that. Why don't you have your in-house legal department do that, or something like that? Here's
Great.
Another question.
Oh, yes. Sorry. One more question just came in. Go ahead.
Can the payment certifier act as an adjudicator if they are certified as an ODAC adjudicator? I believe the act refers to an independent certifier, which interestingly is not defined. So I think if the parties agree and the independent certifier is willing to act, if they are accredited by ODAC, I don't see why not, based on how the act is worded. But it's kind of an odd provision in the act that's not very well explained. So I believe so, provided that the parties agree. And I think it has to be in writing, and they have to have that accreditation.
Yeah. The parties would have to agree, because they're going to be paying you. One of the reasons, there's lots of reasons why they would need to agree, but one of the reasons is they're going to be paying you an additional fee, right? That's somewhat outside of their control for you to be deciding this on a project that you already work on. Some owners might want that. Some owners may not be comfortable with that.
I think that's all the questions.
That's all we have. That's how I can see anyway.
Yes, yes. So if there's no further questions coming in, then I think we can wrap up for today. Thank you so much to Lena and Katie for this really excellent, very, very informative webinar presentation. I'm sure our members benefited greatly from the information and for the discussion as well. And thanks to everyone who attended and submitted your questions for Lena and Katie. As we conclude this webinar, I have a few announcements that I want to draw everyone's attention to. So again, for those who are seeking continuing education learning hours, the OAA will record your participation in this webinar on your OAA transcript. So there is no need for individual reporting on your part. We just kindly ask for your patience at this busy time of year as we process and confirm the accreditation of your hours within the next few weeks. All attendees will soon receive a PDF copy of the presentation, as well as a link to a survey to submit your feedback for today's speakers. Us at the OAA and our presenters highly value that feedback. So if you get a chance, please make sure to fill that out. And finally, our next webinar will be taking place on Thursday, January 29th, and it will be hosted by the OAA's Continuing Education team with the title Introduction to the OAA Continuing Education Program. In this webinar, myself and my colleagues, Claire Hepburn, Ashley Ward, and Ty Belisario, will talk about the benefits of participating in the Con Ed program, as well as covering key policy updates and the process for logging your Con Ed hours. Registration for this webinar is still open, and the webinar is free for OAA members, so be sure to sign up so that you don't miss any of this important information as we move towards the end of cycle in June of this year. So with that, I thank you all once again. Thank you again to Lena and Katie. Thank you everyone for your attendance and have a pleasant remainder of your day. Thank you.
Thank you.
Thank you very much.